All right, as we've seen repeatedly these past few years, one wrong pronoun and your career could be at risk. Frankly, it's mind boggling that this is where the woke crowd has led us as a nation. And we already know where we're headed next if Democrats continue their majority in Congress. Punishments for anyone and everyone who refuses to play along with this moral make believe confusion. This could extend to everything from the Equality Act passing Congress to something as simple as what teachers and professors are legally mandated to address students by. But perhaps there is a glimmer of hope in the case of Shawnee State University philosophy professor, Dr. Nicholas Meriwether. His attorney, Logan Spena, joins us now with some good news. Logan, welcome to Washington Watch.
Thanks so much for having me.
So it appears that the university there, Shawnee University, may not be very good with biology, but they're getting a math lesson.
In this instance, what the lesson they're receiving is how to comply with the United States Constitution. A philosophy professor, Dr. Nicholas Meriwether, was punished for his refusal to use terms to refer to a student that are inconsistent with that student's sex and with the message that Dr. Meriwether wants to communicate. And the Sixth Circuit Court of Appeals found that that violates his First Amendment rights.
And so they have settled this case with $400,000. But they don't seem to be very repentant about it. The articles I've read seems to be that they're still just as militant about this as they had been previously.
Either way, they're going to be compelled to respect the rights of First Amendment professors. And that's what's important about Dr. Meriwether's stand. The trend that we're seeing of trying to require teachers and professors to affirm an ideology about gender or sexual identity is growing across the country. But people like Dr. Meriwether are standing up, and they're finding, with good help, that the First Amendment protects their rights.
So, Logan, let's back up for just a moment. Share with our viewers and our listeners how this whole case came about.
Sure. Way back in 2018, Dr. Meriwether, who, as I mentioned, teaches philosophy, was requested by a student to use terms to refer to that student with feminine titles and pronouns, and the student is a male student. As a philosophy professor, Dr. Meriwether understands the power of words, and he was unwilling to use those terms to communicate a message that someone's gender or sexual identity is based solely on their subjective identity and not their sex. But the university wanted to compel Dr. Meriwether to express a contrary view. And so they punished him for that, and Dr. Meriwether brought a lawsuit, which made it up to the Sixth Circuit Court of Appeals, which ruled in his favor and said that the university could not condition his ability to hold a job as a professor on his willingness to affirm the state's orthodoxy.
So they've had to settle, in this case, pay him damages and legal fees. Does this set a precedent for other cases where, because this isn't the first, and I know ADF is actually representing other teachers both at the collegiate level and in high school and secondary education level. Does this set a precedent?
It does. The Sixth Circuit's opinion sets a precedent that's binding on all the courts within the physical jurisdiction of that court. But the court also sets a lot of guideposts for courts across the country on how to address this issue. That's because it precisely lays out a really compelling analysis on really kind of every legal front that deals with the issue of compelled pronouns in school. So it found that the important interest of the university in viewpoint diversity and allowing professors to engage in scholarship or teaching is protected by a rule that protects professors. It also found that the actions of Shawnee State would have violated his free exercise rights as well. So the Meriwether case is an excellent precedent for courts across the country and universities who simply want to avoid big damages and fee awards like this case. If they just want to read the opinion and follow the First Amendment that way, we think that would be an excellent way to go.
You know, this is good news, but it's not. We shouldn't necessarily be surprised, although encouraged by it, when you have individuals that are standing up to defend First Amendment and whether it's speech or religious freedoms. When you have groups like Alliance Defending Freedom that are willing to take them to court, 9 times out of 10, they do win, but you just have to have men and women who are willing to stand up for those freedoms that we have, because if we don't stand up, we will lose them. Not because we'll lose them in the courts, but because we won't defend them to, the institutions that the left has taken over, like higher education.
That's a critical point. Forces in the culture are trying to exact a high price for people who want to stand up for the basic idea that there are such things as sexes, or that there are such things as males or females. People like Dr. Meriwether or Tanner Cross and Monica Gill in Virginia, or Peter Vlaming in Virginia, these people are examples, but they show that we need more. We need more people who are willing to stand up and say that enough is enough on this issue. And they're finding that the First Amendment does protect that speech.
Yeah, and they also know when they stand up, Logan, they don't stand alone, because there are organizations like Alliance Defending Freedom, Liberty Counsel, First Liberty, and others that are willing to defend these fundamental rights, because if we don't, we will absolutely lose them. So, look, congratulations to Alliance Defending Freedom for winning yet another case in defense of this vital freedom of ours, freedom of speech and freedom of religion.
Thanks very much, Tony.